So these were the rights of the partners. Now let's see what are the duties of the partners. First duty is carry on business. Now, if you remember, this was one of the rights also. A partner has a right to get himself involved in the day-to-day activities of the firm, in the business of the firm. Now, this is his duty as well. Since he is the owner, he cannot say, okay, I'll not go to work today, or I'll keep employees. I mean, that will not do justice to his business. He has to be very sincere about his business. It is his duty to do whatever is in the greatest common advantage of the firm. Greatest common advantage means what is the most beneficial for the firm. Most beneficial for firm. So he has to work towards the greatest common advantage. Whatever actions are required, whatever decisions are required to be made, whatever work needs to be done so as to work towards the greatest common advantage, he should do that, and he has to do that. It is his duty. Along with these things, it is also his duty to be faithful with the firm, to be faithful with the other partners. He cannot be secretly taking profits. He cannot be goofing up with the accounts. So he has to be very faithful. And he has to render true information. Whatever information is asked from him about the business, about the accounts, about the flow of money, he has to give true information to all the partners. So you see, there's a lot of responsibility on the shoulder of the partner, that he has to work for the greatest common advantage. He has to be very faithful with the other partners, and also he has to share all the true information that he has about the business, about the future prospects, about the accounts, about the sales, the debtors, creditors, profits, or any sort of information, stocks, any sort of information. He has to render true information. Next is indemnify for his fraud or willful neglect. Now again we see the word indemnify. This we had seen in the rights as well. In the rights we saw that it is his right to get indemnified by the firm. There we were speaking from the partner's viewpoint, that if the partner has suffered a loss because of the firm, then he has a right to get indemnified by the firm. Now we are saying, if the firm has suffered a loss because of this partner, it is quite possible that a firm may suffer a loss because of the partner, then it is the partner's duty to indemnify the firm. Indemnify means to make the loss good, to compensate. So I'll give you an example. ABC are three partners in the firm. The firm is in the business of selling cotton. Now the partner A liked a certain cotton, certain quality of cotton that he had gone to purchase. Now since he liked it a lot, he purchased that cotton. Possibly it was very soft, or it was very white in color. Whatever the reason may be, he liked it, so he purchased it at a higher price, because he did not want that somebody else should be able to buy it. Before anybody else bought it, he bought it at a higher price. Now because of this, the firm had to suffer a loss because he bought the cotton at a higher price. The firm had to lose money. If you incur more cost on your products, it is quite understandable that you lose money. It's a loss. It may not result in actual loss, but at least it's a loss in profit. Let's say otherwise you would have earned 10 rupees per bag. Now since you have purchased it at a higher price, you have given 6 rupees more per bag. Now you will earn 6 rupees less per bag. You'll earn 4 rupees. Okay, agreed. You are still earning profit, but your profits will decrease. As a result, your share in the profits will also decrease because profits will decrease. So now the firm has incurred a loss. Now this partner has to indemnify. Not only this, the important thing that here we are talking about is fraud. If any fraud is conducted by the partner, he embezzles some cash. Let's say there was a cash of 1 lakh rupees at the counter and he takes it away. Now it's a straightforward loss of 1 lakh to the firm. Now it is the duty of this partner to compensate the firm, to indemnify the firm. Or willful neglect. Now what is willful neglect? Willful means purposely done. It was willfully done, intentionally done. Neglect means when you don't pay attention. So what you have done is you have purposely ignored something, and because of which the firm has incurred a loss. I'll give you an example in this regard. Yours is a firm, let's say you are 3 partners and yours is a firm which deals into cotton. Now suddenly there is a news that the prices of cotton will fall from the next month. Okay. Now yet you do not try to sell off the cotton. The stock that you have, if you sell today, you'll get the full price. However, if you sell the same cotton after the month, you let's say sell it at 70%. But you willfully neglect this fact. You say, oh, ye sab chalta rehta hai, nothing will happen. So now what you're doing is you are willfully neglecting a fact because of which now the firm will incur the loss. You got the news. Now it was your duty to act on this news rather than willfully neglecting it and saving the firm from profit. But what you did was you willfully neglected it. There was negligence on your part. Now since there is negligence on your part and the firm is incurring loss because of your negligence, you'll have to compensate the firm. You'll have to indemnify the firm. The next duty of partners is to attend duties diligently without remuneration. To attend the duties, whatever duties has been agreed by the firm upon that partner, he has to do them diligently. What is the meaning of diligently? Carefully and meticulously, without remuneration. Now if you remember, in rights also we had done that it is a right of the partner to get remuneration, but we said normally if you ask, we cannot say that it is a right of the partner. It becomes a right only when it is mentioned in the partnership deed. Only when the clause relating to the remuneration of the partners appears in the partnership deed. So here also same thing is mentioned, to attend the duties diligently without remuneration. He should not ask for remuneration for attending to duties, because this is what he has made partnership for, to attend to duties, to do business and to earn profit. So he should not be expecting some remuneration for doing these things. However, if all the partners agree, you know and there's a clause in the partnership deed in regards to this, then they may take remuneration. Otherwise, the partners are not supposed to take remuneration. Next, have partners advantage of his knowledge. Now, if some partner has some skill set, some knowledge, then it is his duty to impart that knowledge to the firm, or impart the advantage of that knowledge to the firm. You know, let's say I have a skill set wherein I am very good at organizing the things. Okay, but in my firm, I do not organize anything. Everything is unorganized and everything is out of its place. I have not maintained systems for organization. There's no indexing of files. There is no proper filing. There is every file is here and there. There is no a place for everything. Normally we say there should be a place for everything and everything should be in its place. But I don't pay attention to all these things. Then it is my duty that I should give the advantage of the skill set to my firm. Okay, let's say I am very good at maintaining accounts, so I should give the skill set, the advantage of these skills to my firm. I should be maintaining the accounts for my firm. If I don't maintain, I should keep somebody and have a watch over him. I should be checking the accounts of the firm and see to it that everything is being done properly. So whatever skill set, whatever information, whatever knowledge the partner has, he should use it for the advantage of the firm. Okay. Again, in the rights we said, to share the profits of the business is the right of the partner. So to share loss automatically becomes his duty. If sharing profit is his right, sharing loss becomes his duty. Now the important thing here to understand is, in what ratio do we share the losses? If it is mentioned, if the ratio is mentioned in the deed, then we should share the losses in that ratio. If the ratio is not mentioned, then we should share it in PSR. So the losses should be shared as per the agreement. If not in agreement, no ratio is given in the agreement, then in PSR. Okay, then we should share in PSR. Next, return personal profit from firm's assets or name. Whatever profit a partner has earned individually by using firm's name or firm's assets, then he should return that profit to the firm. Okay, I'll give you an example. There are two partners in the firm. Okay, L and M, and their firm name is Measures L and M. Okay, or LM and Company. Now L uses his firm's name and secretly does business, because his firm is very big, it has a reputation, but the problem is he only gets half of the profit, half he has to share with M. Now what he is doing is he is doing his own business in his firm's name. He tells his suppliers that he is purchasing for the firm. He tells his debtors that he is selling them on the firm's behalf. However, he does it on his own account. He does not give the credit to the firm. He does not show the transaction in the firm's books. So now what happens is, since he is making personal profit by using firm's name, he should give such profit to the firm and then get it distributed. So a partner cannot make personal profits by firm's business or using firm's asset. For example, a partner gives firm's car on rent, on hire. He uses firm's car on hire basis. He gives it to his friends and relatives, and he takes higher charges from them. So now whatever higher charges he gets, he should give it to the firm. It should be applied to the firm. He cannot make personal profits from firm's assets or firm's name. Okay. Next, return profit of competing business. Now, partners enter into partnership business. Why? So as to do business and to earn profits from it. Now, if a partner also does a competing business, being a partner in the firm, he's a partner in the firm and also he's doing competing business as a sole proprietor also. Now, do you think that is logical? He should be doing that. If he wants to do his own business, then why is he into the partnership? That doesn't make sense. He should either be in the partnership or be in his competing business. And if he is doing both, he should give the profits that he is earning from the competing business to the firm. This is just like the sixth point, the above point. In the above point, we said if the partner is using firm's name or firm's asset and earning profits, he should give it to the firm. Here we are saying if the partner is earning profit from the competing business, a business which is of the same line, of the same nature, it is of competitive nature, and if he is doing that business, if he is earning profit from it, then he should give the credit to the firm. He should apply the profit in the firm's book and probably then get a share from it. But he cannot be doing competing business, and if he does it, all the profits belong to the firm. So these are the duties of the partners.